there are a number of rights that people get if I'm governed by HIPAA. Let's assume for the moment that we are, just for the sake of argument, okay? If we're covered by HIPAA, people have a right to notification about their privacy rights. They have a right to know about the information that I'm using about them and that I'm disclosing about them. And interestingly enough, in most states, they don't have a right to consent or refuse to consent to disclosures of routine medical information, which means many people simply have no right to, I mean, just like with financial information, we can't prohibit an insurance company exchanging information with our physician, okay? That they're allowed under HIPAA. Now, California, for mental health services, has a higher standard. It gives more rights to privacy. So it says that we can, as consumers, say, I don't want you exchanging information with anybody else, okay? Particularly for mental health concerns, substance abuse concerns. There's actually higher statutory protection federally for substance abuse information and treatment information. So even though in California you could, or under HIPAA, you could argue that there's no right to consent to routine disclosures, just notice in good faith, our standards for mental health services in California are higher. So we actually let people decide under what's called an authorization whether we can disclose or not disclose routine information about their care. Now, the other thing that HIPAA says is that people can have access to records. This is one of the other main points that I want to make. And that is that our previous access to records rules, the rules that we would abide by if we were not covered by HIPAA in California, so if you haven't taken a bite out of the apple, okay, include that we can decide not to give a person any record at all and just refer them on to somebody else to interpret the record. We could give them a summary at our discretion. We can show them a copy, or we can disclose the whole thing. We can share a copy with them. Under HIPAA, however, our options, if we are covered by HIPAA, are different. So if I'm a HIPAA-governed provider, then the exceptions to the rule that I have to give access to the person's healthcare record are more narrow in some ways. They are only if, for example, I have a reasonable likelihood, the information would have a reasonable likelihood of causing physical danger to my client or somebody else. That's very unusual. Could happen, but very unusual. If it's for research, so if we're doing a study that involves a placebo effect that both groups are not told about, we don't have to inform them and undermine the research, okay? So that's another exception to this idea of access to the record. And then third, if the record is being developed in anticipation of a lawsuit. So I'm putting together a workers' comp case. I don't necessarily at this point have to share the record with the client, all right? The last exception I got very excited about when I first saw it, which is that clients do not have access to their psychotherapy records. And the reason I got excited about it is I thought somebody was actually thinking in Washington. And they realized that it's different to get access to a psychotherapy note than it is to a typical medical record. I mean, when I look at an MRI, all I am is confused. I'm not ashamed. I'm not scared by it, well, a little bit sometimes, or whatever maybe, but it doesn't mean very much to me. But when a person has access to a mental health record, there's a lot of potential for emotional damage and also damage to the relationship. So I thought, great. Then I made the mistake of reading further in the statute, and actually the regulations. And the regulations define a psychotherapy note in the following way. It says that a psychotherapy note are notes by the mental health professional about contents of sessions. Okay? And it can be any type of session. And they have to do with the therapist's impressions about the patient, details of conversations that would be inappropriate for the medical record and are kept separately from the medical record. Now, what do they mean by this idea of a medical record and keeping it separate? I don't know any clinician who keeps a separate, private practitioner to be sure, but even in clinics, Kaiser's different because there are different separate records, but for the most part, most agencies have one record for a person. You know, it's not defined as the medical versus psychotherapy, it's their psychotherapy record, it's their clinical record, okay? So I wanted to find out more, like how do they define this medical record? This is what a medical record is. or the reverse way of saying it is, this is what a psychotherapy note does not include, what they're defining as a medical record or routine record, right? It's notes about medications, the frequencies of service, the types and times, raw test data, as you were talking about, any summary of diagnosis, functional status, treatment plans, symptoms, prognosis, and progress to date.